That structure violates covenant restrictions. She pointed at my fence posts like they were evidence at a crime scene. I still had dirt on my gloves. Freshly driven posts standing in soil my family had owned for over 3 decades. I looked at the woman, then at the government truck idling behind her, then back at the posts. "Ma'am, you're standing on private land." She stepped closer, a laminated badge catching the morning sun. "Not according to our records. This parcel was absorbed into the Ridgecrest Rural Community Association 14 months ago. You're currently in violation." 14 months. I had inherited this place 11 months ago. Do the math on that and tell me what you get. What followed that Tuesday morning in the high country of western Montana would pull back the curtain on something far more organized, far more predatory, and far more widespread than a boundary dispute between a new landowner and a neighborhood association. This is the full story of what happened, what I found, and what we did about it. Let me take you back to the beginning, because the beginning matters. My uncle Gene passed in late winter, and after 4 months of navigating probate court, attorney fees, and estate paperwork that seemed designed by someone who hated human beings, I became the legal owner of 62 acres of high-elevation grassland in Sanders County. Gene had run cattle on that land for 28 years. Before him, my grandfather had used it for hay production. Before that, it was wilderness. The deed was clean. No liens, no easements beyond a single utility corridor on the northwest corner, no covenants, no restrictions, no association membership of any kind. I had a title company verify all of this before closing. 3 separate documents confirmed the property transferred free and clear. I moved up in September. Not permanently, I still had a job in Missoula, but I drove out on weekends to work the land, do maintenance, and start planning what I would eventually build there. The house on the property was a modest structure Gene had built himself in the early 90s. Solid, practical, not pretty. The fencing situation was a different matter. A section of the eastern boundary had deteriorated badly, and cattle from the neighboring parcel had already wandered twice into my pasture. My plan was simple: rebuild the eastern line, establish clear markers on the southern boundary, and eventually string new wire on the western slope where the original fence had rusted to nearly nothing. I started that project on the second Tuesday of November. Clear sky, no wind, ground still soft enough to drive posts without power equipment. The kind of working day you hope for in Montana before the real cold sets in. I had my father's old post driver, a roll of 5-strand barbed wire, and enough steel T-posts to complete the eastern run. I was on post 14 when I heard the engine. Not a rancher's diesel, not a county road maintenance vehicle. Something heavier with a particular kind of official growl that you register instinctively before you consciously identify it. A state ranger truck came around the tree line at the southwest corner of my access road and pulled up 20 yards from where I was standing. The driver stepped out first, uniformed, clipboard in hand. Then the passenger door opened and a woman got out wearing the kind of business attire that has absolutely no business being in a pasture. Dark blazer, leather folio, lanyard with multiple badges. She walked the way people walk when they expect to be obeyed. She introduced herself as Diane Forsyth, Compliance Director for the Ridgecrest Rural Community Association. The ranger, whose nameplate read Harmon, stood slightly behind her like a prop. A visual confirmation that whatever she was about to say carried official weight. "Mr. Callahan," she said, using my last name in the way that signals a conversation has been researched in advance. "We're here regarding unauthorized construction activity on a property under Ridgecrest jurisdiction." I set down my post driver slowly. Not because I was nervous, because I wanted my hands free and my posture calm. "I'm building a fence on my own land," I said. "There's nothing unauthorized about it." Forsyth opened the leather folio and produced a document, multiple pages, county letterhead on the cover, official seals. "Your parcel was incorporated into Ridgecrest Rural Community Association effective September of last year under the Valley Cooperative Extension provisions. Any fencing, grading, or exterior construction requires prior written approval from our Architectural Review Committee." She said this the way someone reads from a script they have memorized because it is the same script they deliver repeatedly. Not nervously, routinely. The ranger handed me a cease and desist letter. I held it the way you hold something you do not yet understand but suspect you should not put down. I told them there had been a mistake, that I had documentation showing the property transferred without any association encumbrance, that I had never received notice of any HOA enrollment, that my title search had shown nothing of the kind. Forsyth's response to all 3 points was the same. Administrative records reflect the current status of the parcel. Dispute procedures are available through proper channels. She photographed the fence posts from multiple angles. Harmon noted something on his clipboard. Then they left me standing in the wind holding a cease and desist order for building a fence on land my family had owned since before either of them was probably born. That evening I sat at Jean's kitchen table and tried to construct a rational explanation for what had happened. The cease and desist referenced an incorporation date of September the previous year. I had taken possession in August of the same year, which meant, according to this document, my property had been enrolled in a community association 1 month after I became the legal owner, without my knowledge, without my signature, and without any notification that reached me. I called the title company that had handled my closing, left a message, called my attorney, left another message. Then I did the thing that anyone does when they suspect something is wrong and they are alone at night in a house without reliable internet. I went through every piece of paper in the place. Jean had been organized in the way of men who trust no institution and keep records of everything. Filing cabinet in the back bedroom, contents sorted by year. I pulled everything from the last 4 years and spread it across the kitchen table like a map I was trying to read by feel. Tax statements, utility correspondence, county assessor notices, a water rights renewal form, nothing mentioning Ridgecrest, nothing mentioning any homeowner or community association, nothing suggesting any voluntary enrollment in any cooperative agreement of any kind. What I did find, tucked into a manila folder labeled with just a question mark, were 3 letters, each one from a company called Prairie Valley Development Partners. The first, dated 3 years before Jean died, offered to purchase the property at what the letter described as a generous market rate valuation. Jean had handwritten a single word across the face of it, no. The second, sent 18 months later, framed the conversation differently. Not a purchase offer, but an invitation to join a rural cooperative that would provide shared infrastructure benefits and legal protections for participating landowners. Jean had written 2 words on that one, not interested. The third letter, dated 8 months before his death, was different in tone. More formal references to county partnership frameworks and state cooperative statutes. No handwritten response on this one. Instead, Jean had written a separate note on a yellow legal pad that he had paper-clipped to the letter. The note said, "These people will not stop. If something happens to me, do not let anyone tell you I agreed to this. I told the man who came to the house that I would never sign. He left angry. Watch for these letters." I read that note 4 times, then I went to bed and did not sleep particularly well. The following Monday I drove to the county seat and spent 3 hours at the assessor's office. The clerk who helped me, a patient woman named Ruth, who seemed genuinely troubled by what she was finding, pulled up the parcel records on her terminal and confirmed what the cease and desist had claimed. The property was listed as incorporated into Ridgecrest Rural Community Association, effective date 14 months prior. It went through as a cooperative boundary extension, she explained. That's a mechanism under state statute that allows established associations to expand jurisdiction over adjacent unaffiliated parcels under certain conditions. She looked uncomfortable saying this.
"Conditions?" I asked. She typed something, studied the screen. Consent documentation from the property owner of record at the time of incorporation. The property owner of record 14 months ago had been Jean's estate. Jean himself had died 10 months before that. His estate was being administered by a probate court that had a single attorney filing paperwork for a dead man's land holdings. Nobody had been home to receive consent documentation, nobody living anyway. I asked Ruth to print everything she had on the Ridgecrest Incorporation filing. She handed me 11 pages.
The signature authorizing consent on behalf of the property was a single cursive name on a line labeled Estate Representative. I took a photo of that signature with my phone. Then I went to the courthouse and pulled the probate file for Jean's estate. The estate representative of record was the court-appointed administrator, a Kalispell attorney named Peterson who had handled the procedural filings. I called his office from the parking lot. His paralegal confirmed that their office had signed nothing on behalf of the estate related to any homeowner or community association enrollment. She sounded certain. I asked her to check the file. She put me on hold for 4 minutes. When she came back, she was more than certain. She was offended. Mr. Peterson does not sign property covenants on behalf of estates. That is not within the scope of estate administration. Whoever signed that document was not us. I drove home with 11 pages of county records and the growing certainty that what I was dealing with was not an administrative error. The escalation came in waves, which I later understood was by design. The second visit happened 5 days after the first. This time Forsyth came without the ranger. She brought a younger associate instead, a man who introduced himself as the association's field coordinator and spent the entire conversation taking photographs and saying nothing. Forsyth delivered the next stage of the pressure campaign with the same practiced calm she had used the first time. My accumulated violations now included continued construction activity, failure to respond to the cease and desist within the required 72-hour window, and what she described as willful noncompliance with community standards. She handed me a fee schedule, daily fines beginning at $300. lien authorization procedures, a timeline for escalated county enforcement. We want to resolve this cooperatively, she said, with genuine-sounding sincerity that I suspected came from years of practice. The association can grandfather your existing fence posts if you agree to submit future projects for review and pay the outstanding administrative processing fee. The fee was $1,400. I told her I would need to consult with my attorney. She left a business card and a payment schedule. The field coordinator photographed my mailbox on the way out. I do not know why. Maybe it was just habit that night. I called my neighbor Dale, whose property ran along my northern boundary. Dale had been ranching in the valley for 31 years. He had the specific Montana manner of a man who says very little but means everything he says. Ridgecrest, he said when I explained the situation. Pause. Never heard of them before 2 years ago. Showed up at the Hendersons' place, then the Morrisons. Marla Morrison signed something she thought was a road maintenance agreement. Turned out to be cooperative membership enrollment. She's been fighting the fees ever since. He paused again. Your uncle didn't sign nothing with those people. I can tell you that firsthand. He called me after they came to his place the second time. Said they were vultures in polo shirts. I asked Dale if he knew anyone else in the valley who had been approached. He gave me 4 names. I called all 4 the next morning. Every single one of them had a version of the same story. Official-looking people convincing documentation, pressure framed as helpfulness. 2 had signed under what they described as confusion about what they were actually agreeing to. 1 had refused and subsequently discovered a lien filed against her property for unpaid association dues she had never incurred. 1 had received a cease and desist for a fence project nearly identical to mine. The pattern was not subtle once you could see the whole shape of it. The documentation phase is where everything shifted. My attorney, a Helena woman named Carol Danes who specialized in property and water rights, drove up the following Saturday and spent 5 hours at Jean's table, going through everything I had gathered. The county incorporation filing, Jean's letters from Prairie Valley Development Partners, his handwritten note about refusing to sign, the probate records, the signature comparison between the consent document and Peterson's firm's confirmed non-signature. She was quiet for most of it, not hesitant quiet. Analytical quiet. The kind of quiet that means someone is building something in their mind. When she finally spoke, she was precise. The consent signature is not from the estate administrator of record. That means the incorporation filing either used a forged signature or a signature obtained from someone without authority to provide it. Either way, the legal foundation for Ridgecrest's jurisdiction over this parcel does not exist. She set down the papers. This is not a gray area. She contacted Peterson's office formally to obtain a sworn statement confirming that no one at his firm had signed the consent document. That statement arrived by email within 48 hours. She pulled the Ridgecrest Incorporation filing from the state database and identified the name of the entity that had submitted it, not Forsyth, not the association itself, but a third-party filing service with a registered address in a commercial district in Billings. She requested the full membership roll from the county through a public records request. What came back showed 47 properties in the valley listed under Ridgecrest jurisdiction. She cross-referenced ownership histories. 11 of those properties had changed hands within 24 months of the incorporation date. 3 had been in probate during the period when consent documentation would have been collected. Dead people's estates, absent heirs. Landowners deep in grief and paperwork who were not watching their property records. These were not random targets. I asked Carol what we should do. She said the answer had 2 parts. The first was legal, challenge the incorporation validity, file for removal of the lien, seek declaratory judgment that the cease and desist had no legal standing. That part she would handle. The second part was something I would have to decide about. The legal remedy protects you, she said, but 14 of your neighbors are still enrolled in this thing. Some of them are paying dues, some of them have liens. The legal remedy doesn't automatically extend to them. She let that sit for a moment. A public meeting might. Forsyth came a third time 9 days after the second visit. This time she brought the ranger back, and this time her tone had changed in a specific way I had come to recognize as the final pressure stage before systems like this either succeed or collapse. She stood on my porch with a document she described as a final opportunity for voluntary resolution. Sign an acknowledgement of HOA membership, agree to pay the accumulated fees, and submit my fence project for architectural review. In exchange, Ridgecrest would waive the daily violation penalties that had been accumulating since the first cease and desist. The total waiver represented over $4,000 in fees I had never agreed to incur for rules I had never agreed to follow on land that had never been legitimately enrolled in their organization. This is the last point at which we can handle this administratively, Forsyth said. After this, it moves to county enforcement and legal proceedings. She said it the way you describe a weather forecast, not threatening, just informational. Inevitable. I told her that my attorney had reviewed the incorporation documents and had specific questions about the consent signature. Forsyth's expression did not change, but something in her posture shifted, very slightly. The way a person shifts when they have been expecting a particular card to appear on the table. Those concerns can be addressed through the association's dispute process, she said, which requires active membership enrollment. Think about that sequence. You must be a member to dispute whether you were ever legitimately made a member. Carol had flagged this exact circularity in her review. It was not accidental architecture. I told Forsyth I would not be signing anything that day. Ranger Harmon made a note. They left. That evening, Carol filed the declaratory judgment action in district court. The community meeting was Carol's idea, but the execution was mine. I called every neighbor whose name had appeared on that county membership roll and whose phone number I could locate. Some I knew, some I had only met once in passing, some I had never met at all. I explained what I had found, what Carol had filed, and what a public forum might accomplish for the people who were still enrolled and still paying. Most of them came. Of the 47 properties listed in Ridgecrest's records, I reached the owners of 31. 24 showed up to the meeting at the church hall in Knoxon on a Thursday evening in early December. They came carrying documents. That is what I remember most clearly. Every single person who walked through that door had brought something. A fee statement, a letter, a payment receipt, a lien notice, a cease and desist. 24 people who had each been handling their situation alone, each believing they were an isolated case, each uncertain whether their experience was unusual or whether they were simply misunderstanding something legitimate. Seeing 24 people carrying 24 versions of the same document changed the room immediately. You could feel it. The retired schoolteacher from the Morrison Ranch brought a recording. She had used her phone to capture audio of her second interaction with Forsyth, during which Forsyth had made very specific representations about the legal authority of the association and the consequences of noncompliance. She played 90 seconds of it. The room was absolutely silent during that 90 seconds. Then a man in the back row, I later learned he had been paying association dues for 14 months, said something under his breath that I will not repeat here, but that reflected the general consensus of everyone present. Carol addressed the group for 40 minutes. She explained the incorporation statute, the consent requirement, what a fraudulent or unauthorized signature on a consent document meant for the legal validity of the entire enrollment, and what the declaratory judgment action she had filed was seeking to establish. She brought printed copies of the public records request response showing the membership roll. She brought printed copies of the county filing showing the consent document. She brought a printed copy of the statement from Peterson's office confirming that no one at his firm had authorized any signature on behalf of Jean's estate. She laid all of it on the table at the front of the room and told everyone to take what they needed. "This is your property," she said. "The documentation proving that is public record. Every person in this room has the right to request their parcel removed from an association that incorporated them without valid consent." 11 people signed authorizations for Carol to represent them that evening. 3 more called her office by the end of the week. The retired school teacher filed her own complaint with the county attorney's office the following Monday, attaching her audio recording to the submission. The legal process moved with the particular combination of speed and slowness that characterizes moments when the facts are clear and the institutional response is trying to find a posture. The county assessor's office placed a temporary hold on enforcement actions related to Ridgecrest's pending review of the incorporation filing within 2 weeks of Carol's filing. This did not happen because anyone made a dramatic decision. It happened because a clerk in the recorder's office compared the consent document signature to existing records and escalated the discrepancy through normal channels, and the official who received that escalation understood immediately what it represented. The Ridgecrest Association filed a response through a Kalispell law firm that argued the incorporation was procedurally valid and that any signature disputes were civil matters between the association and individual property owners. The district court judge rejected that framing in a preliminary ruling that took 11 days to issue. "You cannot claim jurisdiction over a parcel," she wrote, while simultaneously treating the documentation establishing that jurisdiction as a private civil matter immune from court examination. Forsyth's last communication with me was a letter, not delivered in person, just mailed, that described the situation as a misunderstanding involving third-party administrative contractors and expressed the association's commitment to resolving documentation concerns through cooperative channels. It was the most carefully worded admission of nothing I have ever read. Carol read it and laughed, which was the only time I saw her laugh during the entire process. "They're negotiating their exit," she said. "The declaratory judgment was granted in the spring. My property was formally removed from the Ridgecrest roster. 12 of my neighbors received the same relief through Carol's representation. The remaining enrolled properties were addressed through a combination of individual filings and a county-level review process that the assessor's office initiated using the public records evidence as its starting basis. Prairie Valley Development Partners, the company whose letters Jean had kept and labeled and refused, was identified in the county attorney's investigation as the entity that had engaged the third-party filing service that submitted the Ridgecrest Incorporation documents. The investigation also identified 2 other rural community associations in adjacent counties operating through similar incorporation mechanisms targeting properties in probate and recent transfer status. That investigation is ongoing. I'm not the right person to report on its current status. What I can tell you is what I know now that I did not know when I was standing in that pasture with a post driver in my hand. Rural property in Montana and in many parts of the rural West exists in a legal environment that most people who own it have never fully examined. The mechanisms that govern association formation, boundary extension, and cooperative enrollment were written for legitimate purposes. They were not written with adequate protections against entities willing to exploit the gap between legitimate process and verified consent. Probate periods are particularly vulnerable windows. When a property is in estate administration, the owner is dead and the administrator is a legal functionary with limited authority and limited visibility into what is happening to the property's records at the county level. Nobody is watching, and some people know that. Jean knew they were coming. He documented it. He refused, in writing and in person, every approach. And they incorporated his land into their jurisdiction anyway, using a signature that was not his and not authorized by anyone with standing to provide it, banking on the probability that whoever inherited the property would either not look closely enough or would be pressured into compliance before they understood what had happened to them. The fence posts are still standing. I finished the eastern line the weekend after the declaratory judgment came through. 14 posts in the section I had to stop on, plus the rest of the run to the southern corner. Clean work, straight line, properly anchored. Jean's cattle operation is gone, but I have been talking to a neighbor about leasing the pasture for his herd, and the boundary is now defined clearly enough for that to work practically. What happened on that Tuesday morning in November was not the beginning of my story on that land. It was an interruption, a serious one, organized and predatory and deliberately timed to catch a new owner before they had fully settled into understanding what they owned. But interruptions are not endings. The documentation was real. The neighbors were real. The legal process, when presented with real evidence, produced a real result. If you own rural property, or if you are in the process of inheriting it, please do what I did not know to do until after this happened. Pull your parcel record from the county assessor and read every entry under the encumbrances and covenants column. Check the current association status. If anything appears there that you did not agree to, request the underlying documentation and the consent record that authorized it. You have a legal right to that documentation. Request it in writing. If the signature on the consent record is not yours, or if the person who signed it did not have authority to sign on your behalf, you have grounds to challenge the incorporation's validity. Montana statutes governing rural cooperative associations require authentic consent, not administrative approximations of consent, not signatures from people who died before the document was dated, actual consent from actual property owners with actual authority to provide it. That requirement exists for a reason. And when the people who are supposed to honor it do not, the record you build by documenting the discrepancy is the most powerful thing you have. Jean built that record for me without knowing exactly what I would need it for. He kept letters from people trying to take what he refused to sell. He wrote notes to a nephew he assumed would someday need to understand what he had been protecting. He named the threat clearly and left the documentation where it could be found by someone willing to look. The fence stands on land that belongs to my family. That was always true. It just took a while to make the record match the reality.